A very good evening to you, ladies and gentlemen. I'm super excited to welcome you to the seventh episode of the webinar series, held in English for the year 2022, organized by the Seminars Committee of the Bar Association of Sri Lanka, on a very timely topic, which is salient features of the latest amendments brought into Notaries Ordinance, registration of documents ordinance, power of attorneys ordinance, wills ordinance and prevention of frauds ordinance. As you all know, this webinar series is conducted on the Zoom platform. However, for those who have been unable to register on Zoom, could also join by watching the live stream on the BSL YouTube channel. Sorry. First of all, I would like to thank the Seminars Committee of the Bar Association of Sri Lanka, headed by Mr. Isuru Bala Patabandi, Secretary to the Bar Association of Sri Lanka. And also, I would like to take this opportunity to thank the President of the Bar Association of Sri Lanka, Mr. Salient, President's Council, for all the support and guidance given to us in organizing this webinar series. Today's topic, as I mentioned earlier, salient features of the latest amendments to Notaries Ordinance, registration of documents ordinance, power of attorneys ordinance, wills ordinance, and prevention of frauds ordinance. And joining us today, we have the distinguished panel of experts who worked very hard as a team to bring about these revolutionary amendments, who pioneered in drafting these laws, and they are now ready to enlighten us and share their knowledge and experience. So we have three panelists and the moderator for the day. I now take this opportunity to introduce the esteemed panel and the moderator for the day. First, I would like to introduce Mrs. Shuranti Gunawardana, Senior Attorney at Law, who is the chairperson of the Bar Association Notarial Committee. Her profile will be now shared on the screen. Secondly, I would like to introduce Mr. Gigi Arul Pragasam, Senior Attorney at Law, who led this advisory committee to look into these amendments. And his profile is now shared on the screen. Thirdly, I would like to introduce Mr. Felician Fernando Pulle, Attorney at Law, who also served as a member in the Civil Law Reforms Committee appointed by the Ministry of Justice, and his profile is now shared on the screen. So the moderator for the day is Mrs. Niroda Kalansurya, attorney at law. She was the convener of the advisory committee to the Ministry of Justice for law reforms related to conveyancing, and her profile is now shared on the screen. So I know you have a lot of questions. So members joining the session by Zoom may send in their questions through the Q&A chat box to reach the moderator. So without taking much time, I will now hand over the proceedings to the moderator. Over to you, Mrs. Niroda.
Thanks, Adisha. Good evening, everyone. As you are aware, we have gathered here today to discuss the recent amendments proposed to 5 archives ordinances. I must thank former Minister of Justice, Mr. M.U.M. Ali Sabri, President's Council, for formulating a committee to amend those ordinances. Also must thank the chairman of the committee, Arup Pragasam sir, who gave the leadership and who made this task a reality and who has pushed each one of us to meet the deadline. I also appreciate all the committee members for their effort. Without their contribution, this wouldn't have been possible. So as you are aware, the main objective of these amendments is to mitigate fraudulent transaction and to safeguard notaries and innocent clients and to smoothen the process of execution of deeds. So at the very outset, I must say that certain amendments that are suggested by the committee have been changed without the knowledge of the committee, and therefore in some provisions the purpose has been lost. So we tried to explain this to the relevant authorities and to rectify those after the bill is passed. However, it appears that those were not taken into consideration, some of these. So Arul Pragasam sir will explain to you so what has happened and where the amendments are, which the purpose is lost. So without taking much time, I will move on to the salient features of those 5 ordinances, the amendments actually. So first we will discuss the Notaries Ordinance. What are the things that a notary shall do and shall not do are spelled out in section 31 of Notaries Ordinance, which is being amended recently. If we don't do what we are bound to do, we as notaries will be facing far-reaching consequences. So complaints can be made against a notary to the Supreme Court for professional misconduct or malpractices, and that will lead to suspend the notary, cancel the license, and can impose simple or rigorous imprisonment. Arul Pragasam sir, as per the latest amendments to the Notaries Ordinance, what steps a notary should follow when executing deeds? Over to you, sir. Sir.
Okay. Thank you, Adisha, and thank you, Niroda, for your kind introduction. Good evening to all of you. Before I answer your question, Niroda, I'd like to say a few words about this very special and important bill. Bar Association of Sri Lanka has conducted many webinar series in English, Sinhala, as well as in Tamil, in respect of various topics to educate the legal fraternity, and more particularly whenever the new legislation is passed. Notaries Ordinance in existence far back from 1907 for well over 115 years. Due to this archived legislation, there are many loopholes in the law, and therefore fraudulent transactions have been increased and number of lawyers have been indicted. As a chairman of the Professional Purposes Committee, I'm personally aware there are a lot of frivolous complaints against the lawyers due to these loopholes. So due to the serious errors in this legislation or the loopholes, former Minister of Justice, Honorable Ali Shabri, President's Council, took the initiative to appoint the committee to look into the matter. As you said quite correctly, Nirodha, we worked very tirelessly, and within this stipulated period, namely in 3 months, we gave our report. But I must say, the report is not, or rather the recommendations are not in verbatim in any of these amendments. The amendment suggested by the committee has been modified, varied, altered, and new amendments have been introduced. So I try my level best to answer your question. Nirodha, when in terms of the amendments, when a deed is executed, what steps the notary should take, I will take into 3 stages. For example, first one is a person. When an individual or a person comes to selling a property, what steps to be taken? The first and foremost step that we should take is set out in section 31, subparagraph 17. We have to do a search in the land registry and we must obtain the last entry. It's a must. Section 31(17), subparagraph B, earlier, where there was a particular clause where you can get the search dispensary. Now that particular clause has been repealed because quite a lot of notaries who are engaged in a fraudulent transaction, what they used to do is they used to get the client to sign and say search dispensary. So no longer that kind of activities can be continued. That is the first step. So having done a search, when there are encumbrance, if there are any encumbrance, you must inform the client there is a caveat, there is a private notice, there is a seizure notice, mortgage, anything there, those things must be cancelled prior to doing the deed. The second thing is, all this time, last 115 years, the practice hitherto adopted is in regard to a deed, only the seller or rather vendor is the person who signed. Then in view of this new amendment, it's not only the vendor, even the purchaser too have to sign. In addition to signing, the vendor's signature, addition to the vendor's signature, you have to get the left thumb impression. Either you have to put it either above the signature or beside the signature. In addition to that, you too have to obtain the purchaser's signature too. Then next one, affix the original deed or instrument, the passport size photograph of the executant, certifying the photograph is an identical photograph. Like how we certify, like a normal passport or photograph being certified, similar manner, we have to annex a passport size photograph and say, this is the identical photograph of so-and-so, the executor. That is important. Then the next is, affix the notary seal of the photograph and annex same to the original and should preserve a photocopy of national identity card, passport, driving license there. So the next one is, having annexed the photograph, the next thing, the notary should preserve and keep the identification document, namely either the identity card, driving license, or the passport biopage has to be kept. The next one is, affix the original stamp duty payment receipt on the duplicate or copies of the stamp duty payment receipt to the original as well as protocol. So the payment of stamp duty also must, we have to annex the stamp duty payment to the duplicate and copies to the original and the protocol. Now, if you look at this procedure, what we followed last 115 years is basically when we do a deed of transfer, we just simply get the seller's signature and send the deed for registration. Now, back again, I will say, when it comes to a question of individual, what steps to be taken? First and foremost, we have to do a search in the land registry. It is a must. You can't say, my client said to search dispensary, because that has been now repeated. So having done a search, if there are no encumbrances, if you are recommending the title, then you can proceed with the transaction. As at the time proceeding with the transaction, steps to be taken, you have to obtain the signature of the seller and also the buyer. So having obtained the signature, either above the signature or beside the signature, you have to have the left thumb impression. If the left thumb impression is cannot taken for due to some reason, then the right thumb, then toe, because having taken into consideration the people who lost the hand or some part of the body, they have said that's where the toe or impression also coming in. That's the second. Then the next one, what they have to do is stamp duty payment is a must. Because if you look at so many fraudulent deeds, originals have been sent to land list for registration, duplicate has been not spent, no stamp duty has been paid. To avoid that kind of a fraudulent transaction only, it has been clearly stated that you have to pay the stamp duty. Normally it's annexed to the duplicate. Additionally, copies should be preserved with the notary's copy as well as the original also. You must annex a copy. Client to know that there are instances when a fraudulent deed is done, client is unaware, but they only pay 1 rupee stamp in the original deed. Deed is registered and come back, so the client is not interested. Then the next step that he has to do is original payment receipt, and also in regard to the photograph. The photograph has to be affixed to the original deed. It has to be certified and say this is the identical photograph of so and so. In addition to that, you must preserve a copy of the identity card or the notary license or the bio page of the thing. But I think, Nirodha, as you said quite correctly, I think you could remember, as we in the committee, what we suggested in regard to the photograph, not to annex to the original, to annex to the protocol for the purpose of safeguarding the notaries in the event of any problem. So anyway, that is in regard to individual signing a deed. Now, when a deed is signed by a power of attorney holder, the power of attorney holder, the notary should take a precaution. In the first instance, notary must satisfy either himself or herself whether that particular power of attorney yet in existence. How do you check that? You have to check with the Registrar General's office whether that power of attorney is cancelled or still in operation. The next is you have to get obtain an affidavit from the power of attorney holder to the effect that it is genuine, enforced, and the principle is alive. That's the next one. Then the third one is, in terms of Rule 30, when an instrument is signed by a power of attorney, notary should obtain a certified copy of the power of attorney, obtained from the Registrar General Office, shall annex the certified copy of the original instrument, shall annex that. So, in addition to you have the original power of attorney, you have to also obtain a certified copy from the Registrar General that has to be annexed to the deed. And specifically, notary should be careful when any deed is executed by way of a power of attorney, whether that is a special power of attorney or whether it is a power of attorney given for the purpose of sale. If it is given for the purpose of the sale, it should be a special power of attorney. It should have a schedule or at least the meets and bounds, and to say whether that particular power of attorney authorize or permit the attorney to sell the property. The next question is very often when the power of attorney notary should ensure. There are instances where the power of attorney has been given only for the purpose of execution of the deed, not to collect the consideration. So in that event, notary should be cautious, pay the money or issue the check only in favor of the person who is abroad or who is the real owner. So back again, I'll quickly tell 3 steps to be taken. First and foremost, must verify whether that power of attorney is still valid or enforced and not been cancelled. That's the first step. Second thing, you have to obtain an affidavit from the notary, from the power of attorney to the effect that it is genuine, enforced, and still the principle is alive. Then the third one, you have to get a certified copy from the Registrar of the Registrar General's office. That is in regard to the. Now the third situation is where the seller or the vendor is a company. When a vendor is a company, first and foremost thing, you have to verify that you must check the memorandum and articles of association, who is authorized to sign. There in the memorandum and article, there is a clause to the effect to say seal, whether it is 2 directors or 1 director or a director and a secretary or a CEO authorized person. Then you have to check that. The next one is you have to get the certificate of incorporation. Then also you have to get if it's a purchaser as well as seller, both are companies, then you must get the both company board resolution And if it's a major transaction, you must get, in terms of the Companies Act, section 185, you have to get the shareholders resolution, form 15 of annual return, and form 20 directors detail. Having obtained all that, now who should sign when it comes to a limited liability company? The person who should sign, as stated in the memorandum article, if it's a director, you have to get the two directors' signature. Back again, in that too, you have to get the left thumb impression, or the right thumb impression. You have to get it the authorized person there. So the next one is, in addition to that, when you are attesting a deed, the most other good, Niruddha, I'm taking a little more time. I think other questions may not so long. I'll take time and do, because these are crucial. There are series of questions on this matter. So, and in addition to that, what you have to look into it when you are attesting a deed in regard to the attestation. The attestation has been amended in section 20B of the Notaries Ordinance. It says here as to whether the executor and the witnesses instrument known to the notary. Earlier, the law was, in terms of section 31, subparagraph 9, or the rule 9, to execute a deed, either you should know the executor or the witnesses. Otherwise, you can't do it. But in view of the new amendment, the executors has been interpreted in a different way, either it's the seller or the purchaser. If you either know the seller or the purchaser, that would suffice. And also, the little more lenient situations have been taken. How to identify? They have given a chance to the notaries and say, you can peruse the identity card, driving license, or biopaid, and say how the whom do you know, and how do you verify? Then, when it comes to a question of in regard to the consideration, also in the attestation, you must say how the money was paid, whether it was paid in your presence, whether it was paid prior to the execution, whether it is paid by check or by cash or a pay order. You have to set out all the details. The most important thing, last one, is in the attestation, also it does say specify, and also finally they must say set out the notary's license has been renewed and is empowered to execute sale. In foreign countries, it is there. So now we have introduced here. You have to say that you are having there are instances where the lawyers are practicing, notaries are practicing without renewing the license. So you have to say, I have renewed the license, I'm having the license for this particular year, and also I have already made a renewal there. So those are the main things to be followed when you are executing any deed of transfer.
Thank you, sir, for your kind explanation. One main objective of introducing amendments to Notaries Ordinance is that to safeguard notaries. So we have seen that there are so many charges leveled against notaries by CID, and notaries have fallen into many difficulties while discharging their duties. So unfortunately, Notaries Ordinance didn't have provision to protect them. So if you have noticed the Notaries Ordinance, it doesn't specifically state that identity cards has to be checked by the notary for the identification of parties, and therefore there was a lacuna as to what needs to be done by the notary for the identification and to avoid impersonation. But according to the amendments, it specifically states that identity cards has to be checked for the identification of parties, and if notary has done so, you are discharged from your duty. Madam, what measures have been taken by the recent amendments to Notaries Ordinance to safeguard the notaries against frivolous complaints made by the client?
Thank you, Nirodha. Thank you, Arul. I must tell you that when we sat numerous occasions in Mr. Arul's office to discuss and to amend this act, it was our biggest, we were focused on how to stop the fraudulent deeds which are floating around. As you are well aware, the property prices have gone up, and there were so many frauds that have occurred due to no controls being done in the Notaries Ordinance. With that, we brought in all these amendments which will safeguard the lawyer. So I think the law and notaries should be very happy that the initiative was taken by the committee appointed under the leadership of Mr. Arul Prakasam to protect the lawyers. First and foremost, the photograph. Now, there was never in the history about a photograph. Now here, when a person comes to you, you have the photograph which you affix in your protocol, though we mentioned in protocol, now it's original, and you certify. So that proves that person has visited the office and signed the deed. Then comes the ID cards. Earlier also we used to put at one time there was a regulation part where I used to put the ID card number, but it is not so. Now we have to retain a copy of the ID card. So any day if a frivolous complaint is made, you can show that you have the ID cards in your protocol copy, which will safeguard you from any frivolous complaint. Then comes the thumb impression. As you are well aware, you can say this is not my signature.
Madam, you're on mute.
When it comes to a thumb impression, is not so. Thumb impression is a very acceptable, valid evidence of that person coming into your office. Then comes the party signing the deed. Now that's a very, very intelligent and important move. As you are well aware, when we execute a deed, the person who comes to is the buyer, but the person who signs the deed is the seller. Though we say, and most of these notaries have this habit where they get two of their clerks to scan with the signature to some unknown party. No, it is not so, because we know the seller. If one of the executants are known and the witnesses can claim they also know that executant, you are safeguarded. Then you need not go and answer all these questions that are raised by the CID where you are treated as a criminal if a frivolous complaint is made. Then also comes the attestation. The attestation is much more comprehensive than what was earlier. The attestation fully covers the lawyers. The new act, you are fully covered. Stamp duty. Now, stamp duty, as Mr. Abu Prakasam very well explained, stamp duty is something. There are so many lawyers have fraud. I'm not telling everyone, but there are so many instances where parties have signed a deed of transfer, send it for registration. Then when you looked at the last will, when you look at the deed register, it's only a last will. Recently I came across a party where the company has gifted first property to the one of the directors. Thereafter it has been cancelled and now it has been transferred. When I called for the duplicate of the deed of gift, see, it was a cancellation of a lease. Therefore, this new rule where they say that the stamp duty paid, first they have put the burden on the notary that you have to ensure that stamp duty is procured. Then it goes on to say you have to have the original receipt in the duplicate, a copy thereof in both original and protocol. I think that's one of the things that will really safeguard the notaries. Then comes even where another way that they have protected us is renewal of the notarial license. As you in the new Notaries Act, the renewal of the license is on the 1st of April, not unlike those 28th of February and 1st of March. And there's special section to say that when you go to renew your license, you have to file a declaration saying, I have submitted all my duplicates for the preceding year. Therefore, this act, which has been done very with a lot of hard work, has really safeguarded our law and notaries. And I think we should all appreciate this and go ahead to implement this and to follow suit, thereby protecting our professionalism and our members. Thank you.
Thank you, madam, for your advice. Clients are spending their hard-earned money to purchase lands. Felician sir, what measures that have been taken by the amendment to the Notaries Ordinance to safeguard the clients from the notaries who engaged in malpractices? Over to you, sir. Felician sir.
Thank you, Nirodha. When it comes to notarial practice, there are three parties which are involved in conveyancing. One is the real owners, The second is a genuine bias. Third is a notaries acting with good faith and care. So you have to safeguard the clients from the fraudulent buyers or fake owners, and the malpractices as defined in the dictionary says improper, illegal or negligent professional behavior. That is improper behavior or illegal behavior or negligent professional behavior. That is what is called malpractice. So to avoid that malpractices, we have introduced in the new act by introducing a practical training for new notaries to avoid negligent behavior. So when you pass the conveyancing exam, just because you have passed the exam, you are not entitled to take oaths or act as a notary. First, you have to undergo a practice of 1 year under senior attorney at law who has a practice of over 10 years as a notary. This will give a lot of experience for the new notaries in drafting and attesting deeds and other instruments. Then secondly, it comes to enhancing the fines and penalties. Lots of fines and penalties for the last 100 as Mr. Prakash said, for the last 100 years, from time to time it has increased, but it's not sufficiently increased. So a penalty for practicing as notary without a warrant has been increased to 25,000 rupees. A notary's misconduct has the fine for notary's misconduct is increased to 10,000 rupees. Penalty on notary practicing after notice of suspension has been increased to 500,000 rupees. Then there are some other defects or faults or malpractices done by notaries, knowing or not knowing, which are in a say, one can say it's not a serious matter, but these are those malpractices. Divulging secrets without permission. So, without giving notice, if you change the office, that amounts to malpractice. Then attestation of documents drawn by any other person. Signature of a party or witness on a blank paper. Submitting insufficiently stamped instruments. Deed not being read over and explained. Date of execution of deed not inserting. Form of attestation in a wrongful manner. Deeds not properly numbered. All these small offences are the fines on those things have been increased. Also, for not submitting duplicate, the fines have been increased. There are many other offences where the fines have been increased on offences committed by the notaries. In addition to that, there is a deadline on tendering deeds for registration. There's a 30-day deadline if the deed is within your jurisdiction or the practice area. It's 30 days, otherwise it's 60 days. Here, you have to give an affidavit to say that all the duplicates have been properly handed over to the relevant registrar. Then getting the fingerprints of parties. Power of attorney, section 2 of the instruments coming under section 2 of the Prevention of Frauds Ordinance, wills, deeds. If there are 2 or more sheets, every time you have to have fingerprints on those documents. All these new practices have been introduced to avoid malpractices committed by notaries. In addition to that, getting photographs of parties in transfers, gifts, exchange, and last wills. Also, the payment of stamp duty. Normally, the payment of stamp duty is cast on the customers, clients, but here the duty is cast on the notary. Notary has to pay the stamp duty. Then, extra precautions have been introduced on power of attorney based deeds. So, if there's a deed based on a power of attorney, there are lots of precautions to be followed by your notary. Also, earlier we had the practice of writing search dispense with and getting the signature on the protocol of the buyer. Now that practice has been disconnected, you can't do away with the searching. You have to obtain the extracts of the last entry where the last deed is registered. If a company is involved in transaction, certificate of incorporation and directors list has to be obtained. Then if you go through the attestation, the form of attestation, it's a very, very comprehensive list, comprehensive attestation. It will cover everything. Identification of the witnesses, identification of the parties, the transaction, how the if part payments were made, how it was made, in whose name the pay orders were given, the pay order numbers, dates, the banks, also the stamp duty, how it was paid. Everything is there in a very, very comprehensive manner in the new attestation. Finally, he should maintain the details of a will in the deed register. You can't just say last will and send a transfer deed for registration, but you have to say the names of the parties and the date, saying that it's the last. So these are the precautions. These are the safeguards for the clients from notaries who engage in malpractices. Thank you, Nirodha.
Thank you. Arul Prakasam sir, as far as I know, the effective date of an enactment is the date that the speaker has signed, unless otherwise a date is specifically given in the Act. So, Prevention of Frauds Ordinance was signed on 25th October 2022 by the speaker, and the Notaries Ordinance was signed on 31st of October 2022. Sir, what will happen to the deeds that are signed in between the said period? Arul Prakasam.
Yeah, it's a very important and a very interesting question, Nirodha, because I think last several days, so many lawyers as well as many queries in regard to this issue. As you said quite correctly, the three acts, namely the Power of Attorney Ordinance, Notaries Ordinance, and the Prevention of Frauds, were certified by the Speaker on the 25th, and same was gazetted on the 28th. So, as you know, as a lawyer, by operation of law, the day that the Speaker signs becomes the day operating day. Similarly, in regard to the Registration Documents Ordinance as well as the Notaries Ordinance, the Speaker placed a signature on the 31st, but it is due to be gazetted tomorrow, the 4th. So, there were some instances, I think I was told by one of those firm lawyers, in one instance where a deed was registered, a deed has been executed, a lawyer from Jaffna, is a dowry deed, and did not follow the procedure because they were unaware, and sent for registration. The registrar has returned the deed without registering, saying that it's not in order. So I verified this with the Registrar General, and I got this confirmation today. The procedure that they are going to adopt, as well as there will be a circular issued, although the general rule and the law is the date that the Speaker signs is the valid date and the operative date. As far as the practical issue, not that we are overriding the Speaker's decision, as far as the practical issues are concerned, as most of these lawyers are unaware, also not being educated exactly of the operative date. So the operative date in regard to Prevention of Frauds Ordinance, as well as the Power of Attorney Ordinance and Wills Ordinance, will be the day of the gazetting, namely 28th of October. As far as the Registration of Documents Ordinance and the Notaries Ordinance concerned, it will be gazetted tomorrow. So the operative date will be 4th of October. And there will be a circular issue to all the land registries to this effect.
Thank you, sir. So let's move on to the Registration of Documents Ordinance. Section 32 is amended accordingly. So we have witnessed that brokers of certain, this is related to caveats. So we have witnessed that brokers of certain lands, intended purchasers who have paid an advance payment, and sometimes for personal grudges, people lodge caveats against other landowners. This has come to a level which cannot be controlled, and as the amendments are delaying, Registrar General's Department has imposed certain rules to be adhered by lawyers, by notaries, if someone intends to file a caveat. Arul Prakasam sir, as per the amendments to the Registration of Documents Ordinance, who is lawfully entitled to lodge a caveat?
Yes, Dilo, that's also very, very pertinent and important question. If you look at the section 32, subparagraph 1 of the previous ordinance, it says any person may present a caveat for registration. So the person has been not specified. If you look at the current law, the person has been specified saying that caveat of two things. Either he should have a right, title or interest to a land and claim to have a right, title or interest to a land. So the person who can put a caveat is two categories. A, he should be a person who has a right, title or interest, or a person who should have a claims to have a right, title or interest. So who answer to your question, who could lodge a caveat is clearly stated in the amendment, section 32, subparagraph 1C. The caveato, I'll explain. Caveato includes, the first category is number one, a body of persons, number one. Number two, a beneficiary under any trust affecting a land, the second category. Third, a lawful guardian or the next friend of a minor or a person of unsound mind or mentally deficiency person's guardian and or an attorney, that's like a power of attorney holder, judgment creator, executor, administrator of an estate of a deceased, legal heir, and an intended purchaser who entered into an agreement. But here I must also say, Nirodha, I think you could remember, as you are a very active member of the committee, we specifically suggested the owner has been omitted, spouse or child has been omitted. But anyway, these are the categories who has been named in 32(3)(c). These are the people who can lodge a caveat. Then come back to those persons to lodge a caveat, they also should have an interest. When you talk about interest, include an interest arising from an unregistered deed, instrument relating to a land which incapable of immediate registration, a trust, inheritance either by testate or inter succession, instruments relating to a mortgage, an agreement to sell, or co-ownership there. To put it in a very simple form, the people who the persons who are qualified to put a who are entitled in law to put a caveat has been specified. Now, in a very nutshell form, if you do talk about the persons concerned, they fall into this category. Now, although it's not stated owner, any owner is entitled to put a caveat. You see, most of our people also, we lodge a caveat because a lot of fraudulent deeds have been taken place. We are unaware. In our own land, a caveat has been lodged. When we do a transaction, only the people will get to know. So the person who can lodge a caveat, I'll say the owner of a land, although it's not stated there, it's understood. A person who has undivided share of a land or a parcel, a body of a person, spouse or child, legal guardian, or the holder of a power of attorney, a judgment debtor, etc. Now, say for example, if a mother or father died, if the children has interest, children can put a caveat. A beneficiary under any trust, if there is a trust, there is a dispute in the trust, they can put a caveat. And also owner of a condominium parcel, purchaser. Now there is another interesting question, whether a person who has entered into an agreement to sell, he has not paid full amount of money in regard to condominium, whether he can put it. Yes, he is also caught up with that. So these are the people who can put a caveat, and also a person who has entered into agreement with a developer. These are the people, but of course they must have an interest. So by introducing this legislation, where we have prevented a lot of fraudulent transaction, we have a lot of fraudulent caveat being registered, and more particularly, as you said quite correctly, the brokers who has no interest to the land at all. So back again, I will repeat, the people who can lodge a caveat must first and foremost must have a right or a title or an interest. Having had a right, title or interest, or they must have a claim to have a right, title and interest. It is set out in section 32, subparagraph 1. Then section 32, subparagraph 3 specifies who is the caveator. Then also interest is specified in 32, subparagraph C, Roman 3. So these are the people or the persons who is entitled in law to lodge a caveat. Thank you.
Thank you, sir. Madam, what is the role of the Registrar of Lands in regard to the registration of caveat upon receiving the same for registration, and what precautions we should take to register same prior to registration?
Thank you, Nirodha. A caveat has become a real issue for the country. There were many cases when a deed was given to a broker, where the broker went and lodged a caveat, and when the actual owner wanted to sell the land, actual owner had to give quite a large sum of money to the broker to get the caveat cancelled. Though the registration of documents ordinance provided that the caveat can be cancelled in a summary manner, it was never a summary case. Therefore, with the present introduction of the present registration of documents ordinance, it has been very clearly laid out how the registrar should act when the caveat is lodged. Now the caveat has to be lodged in duplicate, and we have to lodge an affidavit, and in addition we have to file a certificate by the attorney at law, which is very good, because now any person can't go and lodge a caveat unless it is in duplicate. Then affidavit is filed showing that right title or interest that the claimant, the caveat is claiming. In the case the caveat is, if the caveat is not the owner, he shall also send the notices in Form X together with names and addresses to the Register of Lands. If the caveat, once this notice are given, it is the duty of Registrar General, and if it's by a power of attorney holder of an owner who's living abroad, then we should submit original power of attorney together with a certified copy of the power of attorney with the caveat to the registrar. The registrar being satisfied after producing the documents, he should enter in the daybook and he should register it. In addition, he should send those notices which we have filed in duplicate, under which is given in Schedule X1 with stamped envelopes to the relevant parties who are named in the in those notices under registered post. Thereafter, if not only that, in the caveat, when he registers the caveat, if there are any parties disclosed, if I'm not the owner but I've disclosed parties who are the owners, he should also put a minute in the relevant volume and folio stating who are these parties, their names and addresses. And once a notice is sent, application to set aside the caveat should be made. Earlier it was 30 days, now it is 60 days. Thank you.
Thank you, Madam. Felician Sir, what are the steps to be taken in regard to cancellation of caveats and also the process of cancellation of caveat through the order of court? We know that there was a cumbersome process for the cancellation of caveats. So over to you, sir.
Thank you, Nirodha. The cancellation of a caveat can be done either by the caveator or his agents and by affected parties. Firstly, if the caveat is to be cancelled or withdrawn by the caveator, it can be done either by the caveator or by his attorney, if he is dead, if the caveator is dead, his executor, administrator, or legal heir. Or if the caveat was filed by a minor child, his guardian or next friend can cancel the caveat. Also, the minor, upon attaining the age of majority, can himself cancel the caveat. If the caveat was filed by two people and one is dead, the surviving caveator can cancel the caveat. Also, by the official assignee, the liquidator, if the caveat was filed by a company and if the company is liquidated, the liquidator can cancel the caveat, or by a fiscal officer by a court order. The cancellation is done by a written request, but there is no format given. Even in the previous main ordinance, there was no format. Now also there is no specific format, but it should be a request in writing by the caveator himself. Then the steps to be taken: the registrar shall cancel the entry and notify the persons affected by the caveat. Earlier, when the caveat is registered, the registrar informs the affected parties who are the joint owners or the owner of the property. So similarly, when the KVT is cancelled, the registrar should inform those parties that the KVT is cancelled. Then second option, the second status is by somebody other than the KVTO. So this is by filing a case in the competent court within 60 days. Earlier it was 30 days. Now within 60 days of receiving a notice of caveat, any party can file a caveat, file an application to cancel the existing caveat. And if the court orders so, the registrar can cancel the caveat. That is the procedure for cancellation of a caveat.
Thank you, sir. So we'll move on to the powers of attorney ordinance. So executing deeds by using powers of attorney is one way of committing frauds. Sorry to say that. So there were therefore several amendments are brought into the powers of attorney ordinance in order to curtail the frauds. In addition to that, irrevocable powers of attorneys were executed simultaneously when mortgages are executed by finance companies. And when the mortgage is defaulted, property was transferred to the finance company by using the irrevocable power of attorney without the consent of the client. Arupragasam sir, what are the salient features introduced by the amended powers of attorney ordinance? Over to you, sir.
Yes, Nirodha. Now, the main thing is, I think, as far as Sri Lankan powers of attorneys are concerned, it has to be in terms of the PFO, Prevention of Fraud Ordinance Section 2, it should be duly notarial, that is, two witnesses and the notary should attest. Now, there is very often the question arises with regard to foreign power of attorney. To have the validity, who should execute? Now, we have specifically set out here in clause 2, amendment to clause 2, subparagraph B, if it is executed outside the country, number 1, ambassador or high commission or diplomatic officer or consular officer or a person who is authorized to attest such power of attorney according to the law of that country. So those are the people who are authorized to certify a power of attorney. Then earlier law was that it was not mandatory to register power of attorney. It says if the attorney so desire. But under this new amendment, we have now made it mandatory. Not only we have made it mandatory, we have put a time slot or time period specified. If it's a local power of attorney, it has to be registered within a period of 1 month. If it's a foreign power of attorney, to have a validity, it should be registered within a period of 3 months. Then, in addition to that, now the other question arises, if you read section 3, subparagraph 3E, it says, talking about the power of attorney, where the left or right thumb impression of the grantor, where both thumbs of the grantor are missing, thumb impression there. I'll come back to this question of thumb impression. The question is, I think back again, sorry to repeat it again and again, when we drafted this legislation, we only confined ourselves, the thumb impression, only to 2 categories, namely to deed of transfer as well as to deed of gifts. But unfortunately, according to the interpretation given in the Notaries Ordinance to the word grantor, to look at the word grantor, the executor means in relation to if it's a deed of transfer, transferor and transferee, in relation to the other documents or instrument, parties to such deed or instrument. So due to that, and also even if you read the Sinhalese version, it says in regard to the interpretation, Lia Atsankaranna Yanuel and Vikunumopuk Sambandena Bonavita, Vikununkarsa Ganunkar. Anikutupo Sadhana Patra Sambandin Bonavita, Ikiapu Opuyo Sadhana Patra Parshara. So due to this interpretation given in the Notaries Ordinance, I think it's now mandatory, not only the principal, even the attorney to sign, although the power of attorney ordinance, section Power of Attorney Ordinance, Section 3E says where the left thumb impression of the grantor. So I think with the new interpretation, we have to treat not only the principal, even the power of attorney holder, who has to sign. That's also one of the things. The next one is, now they come back to the question of pertaining to a land. It is very essential that the details have to be there. If you are doing a transaction relating to a property, meets and bounds, where the property was registered, volume folio has to be set out. If it's a condominium parcel, the details of the condominium parcel have to be set out, and also come back to the question of who is the signing the power of attorney holder. His national identity card, passport, or driving license has to be kept with the notary. If the power of attorney executed in a foreign country, then the question of thumb impression there it doesn't arise. Now, prior to the execution of any power of attorney, every notary should satisfy, number one, that the power of attorney has not been revoked. That's important. So, how, like what we are doing in regard to the lands at the moment in the land registry, if a deed is executed based on a power of attorney, the notary is duty bound obliged to check with the Registrar General Office whether that power of attorney is still valid and in force. Addition to that, that's important. And as you said quite correctly, Naroda, now due to this fraudulent transaction and also obtaining irrevocable power of attorney and very unreasonably taking the properties of the people, we have now cancelled the irrevocable. There's nothing called irrevocable power of attorney as far as the normal persons are concerned. Irrevocable power of attorney could be given only state institution. Then the other significant which is the power of attorney validity. We are given a time period. It's maximum for a period of 5 years. After 5 years, it's not valid. Then in regard to those are the main features that we have put in the power of attorney. The registration now is mandatory, and also period is, if it is executed within the country, 1 month. If it's a foreign country, within a period of 3 months. So those are the main significant features of the powers of ordinance.
Thank you, sir. So it was a cumbersome process to cancel powers of attorneys under the previous ordinance. We had to publish in the newspapers and all that. Madam, what steps to be followed in terms of the amended powers of attorney ordinance to cancel a power of attorney? Madam? Madam, over to you.
What steps to follow in terms of amended power of attorney's ordinance to cancel the power of attorney? Now, earlier, as you are all well aware, when we had to cancel the power of attorney, we had to publish a paper notice, plus we had to publish in the government gazette, which was a very expensive procedure. And not only that, it may be advertised in the papers. Sometimes we might not know. In the new power of attorneys, there has been a specific section which provides notice to be given by the grantor or attorney to cancel the power of attorney. And thereafter, the cancellation must be done by another notarially executed document. There has to be a cancellation of power of attorney to be done. And that is, and also it must be registered in the, it must be tendered for registration in the same volume folio where the Registrar General is registering cancellation of power of attorneys. But there is also the very special section which has been introduced, which says that in the event of you are unable to get the power of attorney cancelled in a hurry, you can give a notice of intention to cancel the power of attorney, but this notice, which will be registered, will be valid for 3 months until the cancellation is executed. So that way, the cumbersome method of going to for papers and publishing in the gazettes are no longer there. The cancellation is really provided, and also very correctly in the Notaries Ordinance we have pointed out that when you are executing a deed with respect to a power of, being signed by a power of attorney, we should do a search. The notary should do a search of the volume and folios. Therefore, this is, I think, quite foolproof, and we are well protected with this section. Thank you.
Thank you, madam. Felician sir, if a deed is signed by a power of attorney holder, what steps to be taken by notaries in terms of the amendments to the powers of attorney ordinance?
When a deed is signed by a power of attorney, first thing the notary should check is whether the power of attorney is in order. If it comes under the purview of section 2 of the prevention, if the transaction is coming under the purview of section 2 of the prevention of frauds ordinance, then it should fulfill the conditions contained in the power of attorney ordinance. If the power of attorney is signed within Sri Lanka, it should be duly attested by a notary public and contain a description of the land or the condominium property. The prior registration should be there. The thumb impression of the grantor should be there, and the bio page of the passport, NIC or DL should be there. If executed outside Sri Lanka, it should be duly executed in terms of the section, the provisions in the amended ordinance. Also contain a description of the land or condominium and the prior registration and the copy of the bio page of the passport or the NIC or DL. If the power of attorney is executed outside Sri Lanka, the thumb impression of the grantor is not required. So before attesting a deed based on the power of attorney, the notary should examine the relevant volumes of the Registrar General and to see whether it's revoked or cancelled. Also, he should get an affidavit from the attorney to say that the power of attorney is valid, genuine, and the grantor of the power of attorney is among the living. He also have to retain a bio page of the passport, NIC, or the DL of the attorney. Also, under the new amendment, the validity of the power of attorney is limited to 5 years, or until if there's a limitation stated until that date. So you have to check the power of attorney to see what the expiry date of the power of attorney. So normally you can't have a power of attorney which was executed 20 years ago or 30 years ago. You can't use those powers of attorney now. What you have to do is you have to check the power of attorney to see whether it's executed within the specified time period, or the maximum time period is the 5 years. I hope this is clear. You know that.
Thank you, sir. It's very clear. So we'll move on to the last wills ordinance. So as we all aware, so last wills were able to be executed either in front of 5 witnesses or by a notary, in front of a notary. Going forward, it will be in the presence of in front of a notary. So Arupragasam sir, what are the significant changes introduced to the amendment to last wills ordinance?
Before I answer that question, as we are moving on from powers of attorney, there's a very important thing I like to mention. Sorry for taking this time. I think the other acts are not there. Come back to the question of power of attorney. Only very important to know there is a transactional period. If you look at clause 8, subparagraph A, it says every power of attorney executed prior to the date of commencement of this act, which has not been registered under the provisions of section 3 of the principal enactment, which has not been revoked or cancelled, or prior to the date of the commencement of this shall within a period of 6 months from the date of the commencement there. So if there is any power of attorney which has been executed and not been registered, there is a grace period given for a period of 6 months, it can be registered. Then the next one, in same thing in clause 8.2, every power of attorney executed prior to the date of commencement of this act, which has been registered under the provisions of section 3 of the principal enactment, has not been revoked or cancelled prior to the date of amendment, shall continue to valid until there. So if there is any power of attorney which has been given previously, and if it is registered, notwithstanding the provisions of this act, that particular power of attorney will continue. And the third item C under 8C, every power of attorney executed prior to the date of the commencement of this act, which has been submitted for registration and pending registration under these provisions of the Principal Act, the commencement of this act shall be registered there. So three things are there. If there is a power of attorney has been done and not registered within a period of 6 months, you can send for registration. If a power of attorney registered and in operation, notwithstanding the fact new act came into operation, that will be in force until it is cancelled or revoked. The third category, if the power of attorney and sent for registration, in the meantime, this legislation has been passed, notwithstanding the new legislation, the particular power of attorney will be registered and it will be valid. But in any event, as you raised the question there, come back to the powers of attorney ordinance, last will ordinance, as well as the this prevention of fraud. Operative date is of the 28th of October. In regard to notaries ordinance and the registration documents, operative date as per the Registrar General, it will be 4th of November. Now let me answer your question in regard to the last wills. Come back to the question of last wills. Not many changes are there. The most important change I could see, according to the earlier law, I don't know what made them to think like that. For a male to execute a will, he should be 21 years of age, a female 18. Now there is no this gender bias. Now they have said both parties 18 years. That's one of the crucial changes are there. Then the second thing is, very often we come across this question. In fact, I think you too would have faced this situation there. Clients are saying, I'm the son or I'm the daughter. While I'm there, this property has been gifted to a third party, to a niece, nephew, or maybe a complete stranger. So the question put forward by laymen are, while the legal heir, maybe son, daughter, wife, can you gift the property to a third party? So we have answered that question. If you look at section 2, paragraph 2, every testator shall have the full power to make such testamentary disposition as he shall feel disposed in the exercise of such right, exclude any child, parent, relative, descendant, or descendant, or omit the mention of such person without assigning any reason for such exclusion, descendant, omission, any law, usage, custom, now or later. So the point that we are raising there is why if anybody is bequeathing a property, he can leave bequeathing children, any third party can give it. That's one of the changes. Then because I think at the commencement you said, we both said when we suggested certain amendments in regard to the last will, same thing has been gone and put into the Notaries Ordinance. Now the Notaries Ordinance, section 31, section 20, subparagraph H, where it has been, it's not in the Notaries Ordinance, it should have been in the Notaries Ordinance. It has been stated, section 31, subparagraph 20H, when you are executing a last will, you must ensure that the testator is in a good, sound mind prior to the thing. And also, at the moment, back again in the Notaries Ordinance, it is stated there, it should have been in the last will. When we, at present, the practice is to adopt is even in our deed register, what we do is we just say date and a last will. We don't put the name. There are instances where the lawyers who are in malpractice, not sending their duplicates, instead of sending they send a fraudulent deed and say in the monthly list is a last will. To avoid that situation, we have categorically now stated you must maintain the deed register. In the deed register, when you execute a last will, you have to specifically say it's a last will, name, and the person. Then we know who, even in the event of a will is challenged, then we can summon the notary and produce the deed register to show where that particular person has been executed a will there. Then the next one is back again, it is stated, I think this particular amendment too, we brought in the Notaries Ordinance, but it is here. Section 3 of the Prevention of Frauds Ordinance. According to Section 3 of the Prevention of Fraudulence Ordinance, when a person is executing a will, same procedure to be followed. That is, in addition to the signature, you have to get the left thumb impression. So those are the main significant features in the last will's ordinance.
Thank you, sir. Madam, now sir has explained the significant changes introduced to the amendment to the last will's ordinance. When a last will is executed in a foreign country in regard to the properties situated in Sri Lanka, What steps to be followed to prove the last will in Sri Lanka as per the latest amendments to the last will ordinance? Madam?
Can you hear? When the last will is executed outside Sri Lanka, the letters of administration of the where the probate has been issued under Civil Procedure Code with the amendment of 1977 under section 554, you can make an application with the certified copy of the original probate for it to be received in the district court of Sri Lanka. The jurisdiction is vested with the district court of Sri Lanka. Likewise, a paper publication has been done prior to the probate being received, and thereafter, within a period of 12 months, the final accounts have been filed. The procedure is properly laid down in from section 554 U to section 554 W. Thank you.
Thank you, Madam. Arupragasam sir, when a joint last will is executed, is it mandatory to prove the will upon the demise of each testator, and what provisions has been made in the latest amendment?
Yeah, Nirodha, that's also another very interesting question, because I think that it's more than the law. I think the people follow the wrong procedure. I just explain you in a simple language. If X and Y, or a husband and wife, execute a joint last will, and in the will, if they do say, upon the demise of each one of us, it should go to the survivor, and upon the demise of the both survivors, it should go to the children. The very often, the practice is to adopted is, if X and Y has jointly done a will, if the X died, Y thinks by operation of law that divorce on Y is incorrect. So therefore, if there is a joint last will, out of the two people who execute the will, if one party died, the surviving heir should file a testamentary case. Then only the deceased property will devolve on the other person. So in short, if there is a joint last will, the joint last will basically have to prove on two occasions. On the demise of each testator, the property has to be proved. Why? If X and Y execute a will and say, upon the demise of us, it will go to survivor us. If X died, Y has to file action. If Y died, whoever the Y's heirs and say, from X, the property came to Y, we are the heirs of Y, and therefore, property should devolve on us. So in short, when there is a joint last will, the will basically have to be proved twice. The reason is, if the surviving heir will never get the thing unless the title is proved. So if it's a joint last will, simply the joint last will has to be proved on two occasions upon the demise of two testators.
Thank you, sir. Felician sir, we will be moving on to Prevention of Frauds Ordinance. Sir, what are the amendments coming into operation to the Prevention of Frauds Ordinance, the amendment?
Thank you, Nirodha. Prevention of Frauds Ordinance is amended. The section 2 is amended to include the thumb impression of the executors. So, if a transaction is covered under section 2 of the Prevention of Frauds Ordinance, in addition to writing before the writing signed before a notary and two witnesses, thumb impression of all three copies.
So you are not clear. Felician sir.
Can you hear?
Yes.
Section 2 of the Prevention of Frauds Ordinance is amended to include the thumb impression of the executors. That is, in addition to signing, writing before a deed before a notary and two witnesses, thumb impression of every executant is necessary to all copies. Be attached to all copies. In 5 witnesses signing the last will before 5 witnesses will no longer be valid. Witnesses sign and affix his thumb impression before a notary and 2 witnesses. And also you will see in the Prevention of Frauds Ordinance, deeds are to be signed in duplicate. This is wrong. Other than a will, every deed has to be signed in triplicate. So there were a lot of questions about deeds signing in triplicate. It's not the last will. It says the Prevention of Frauds Ordinance says, apart from wills, all deeds should be signed in duplicate. It has been corrected by replacing the word duplicate with the word triplicate. So those are the few amendments brought into the Prevention of Frauds Ordinance.
Thank you, sir. Now the session is open for question and answers. So for the moment, I have received, I think, around 100 questions. I will try to post the questions. Some are irrelevant, some already answered by the resource persons. So one question is, Arul Pragasam sir, I will post this question to you. Even if PO is registered, power of attorney is registered in other districts, certified copies have to be obtained, is the question.
I didn't get the question properly.
Even if power of attorney is registered in other districts, certified copies have to be obtained.
It's a must. In terms of the registration of documents ordinance, you have to get it.
Felician sir, how will the new amendments affect the title registration form?
Title registration or BIMSARI is governed by a separate act, Title Registration Act, which is running parallel to the Notaries Ordinance. So that will not affect the Title Registration Act.
Thank you, sir. Shikranti, please explain how the affidavit should be given when the power of attorney holder is a foreign company.
In the case of the power of attorney holder is a foreign company, the affidavit can be given. Generally, when an affidavit is given by any company or a body corporate, you have to say that I am the director of such and such a company, and I'm duly authorized by the company to declare the contents of this affidavit, and the affidavit has to be sworn into or to be affirmed, and before, if that person is in a foreign country, in that country, before a justice of the commission of court, or before the foreign service officer, or whoever it is, because it has to be given by the director there. If it's a foreign company, if the company is there.
Thank you, madam. Arul Pragasam sir, so please could you clarify how the section 7 of the registration of documents sits with the new rule 30A of the Notaries Ordinance. Section 7 of the registration of documents says registration is not mandatory, but rule 30A says registration is required.
Sorry, Nirodha, can you repeat the question again?
Please could you clarify how section 7 of the registration of documents ordinance sits with the new rule 30A of the Notaries Ordinance. The registration of documents ordinance says the registration is not mandatory, but rule 30A says registration is mandatory.
Sorry, 1 second. Section 7
of registration of documents ordinance.
Section 7.
Section 7 of registration of documents ordinance, which has been not
You're talking about the amendment or the new one?
The previous registration of documents ordinance, not the amendment.
Yeah,
because we have not amended the
registration of documents ordinance.
Until next time, where should the photos of the executants be pasted on the original copy of the deed? Is it first page or near the signature and the fingerprints? How should the photos be certified?
Yeah. As far as the place is concerned, it is not specified. It's the notary will have the option where to fix it there. I think preferably, otherwise the deed will be very ugly when you're there. So you can fix it wherever you want. Having fixed it, you have to certify over the how normally we certify passport photograph. Say this is the identical photograph of so and so. Then you must put the seal. You have to put the seal. You said about the registration documents. Or you read it again?
Registration of Documents Ordinance Section 7 says the registration is not mandatory, whereas which is not amended by us, whereas
Okay.
Notaries Ordinance says Section 30A that we have to send it for registration, the deed. So I think that
So the answer to the question is, I think I set out earlier, Nirodha, the amendments that we have put forward, if it has been done in verbatim, this question won't arise. So I do agree there is a lacuna in the law. The fact is that one act can't supersede another act. It should run through parallelly. So I think this has to be corrected, because all this time in the law, when it comes to a question of registration, it is you get the priority. Now come back to this present situation there. In regard to the registration, is not the priority; it's a must. So not only that, it's become to get it to the validity. So I think if there is definitely a lacuna in the law that has to be corrected.
thank you.
But in Nirodha,
Yes, sir.
that particular section doesn't say that it's not mandatory. It says it will not. The registration of an instrument under this chapter shall not cure the effect of the instrument or confer it upon it any effect or validity. It doesn't say clearly that it's not necessary or not mandatory or something like that. Section 7. You are referring to section 7 of the registration of documents ordinance.
Finishing, sir, the next question I will pose that to you. As per the Transitional Provisions of Powers of Attorney Amendment Act, do the existing powers of attorney executed prior to 25th of October 2022 be deemed not acceptable? It does not contain the immovable property description in relation to the deeds executed in future for the purpose
Yeah.
of
The powers of attorney is executed prior to the act should contain the description of the land. Description of the otherwise it's not valid. It can't get validity.
Okay, sir. Madam, please could you also clarify how Section 19 of the Companies Act sits with the new Rule 15A of the Notaries Ordinance? Section 19 of the Companies Act says that two directors, for example, can sign a deed on behalf of a company. The Rule 15A says the board of directors or an authorized person can sign. Over to you, madam. Madam, is the question clear to you?
Under section 19 of the Companies Act, it says the two directors can sign. But whereas section 15 says the board of directors.
Or an authorized person. Yes, madam.
Yes. Now, actually, the term board of directors does not mean that all the directors have to sign. The board of directors can give a by-way. As Mr. Avita Kasam earlier said, that's generally the article says who should sign, one director, two director, or whatever it is. But then we must obtain a resolution whereby the board will authorize that any two directors to sign, or the board will say so and so a duly authorized officer will sign the document. So there is no clash between the two. Just because it says board of directors, there is no necessity for you to get the signatures of all the directors. It's impractical.
Thank you, madam. The next question is, I think we have already answered. How does the passport photo is certified and attached to the original copy of the document? And there were some questions as to whether we have to take a photograph at that moment or not. So it is a photo, as clearly explained by.
But, yeah, just to add a little Nirodha on that matter.
Yes.
As committee, we decided to fix photograph only for the purpose of protocol, for the precautions of lawyer, not for any other reason. Of course, now as we are annexing a copy, I think for the practitioners, I must say, it is always advisable to have a copy annexed to the protocol. It's very good there. Then just to, I think, add a little further, you posed a question about that. What they had there, Section 7, it doesn't say anywhere that it is registration mandatory. All what he says, the fraud or pollution obtaining such subsequent instrument will have the prior registration shall defeat the purpose. So, as I said earlier, by a registration, all what happened was you get the priority when there is competing two documents. So, there is nowhere it has been stated that the registration is not mandatory. It's not correct. There, so the present law stands the registration is mandatory.
Thank you, sir. This is also again related to the photographs. Arul Pragasam, sir, when executing a deed of transfer through a power of attorney, is that case whose photographs should be affixed, the sellers or the powers of attorney holders?
Yeah. Now the question is, when it's come to a question of executing the deed, the person who step into the shoes as a owner is the power of attorney, not the principal. So at this instance, the person whose photograph we should affix, the person who is placing the signature, that is the power of attorney holder, not the principal. Well, if you do have the principal precaution, you can keep it, but the law requires, as according to the act, it is the attorney's photograph, not the principal. The person who is signing, because if you look at even the section, it says the person who is placing the signature is the one who has been just to for the clarity, executant is in terms of the law. Sorry, yeah, executant means in relation to deed of transfer or transfer, that is the person concerned there. So even in singular, it says so the person is slipping into the shoes of the seller or the vendor, therefore attorney's photograph should be fixed.
And also to add something, Arun, the principal can be out of the country, so you can't certify the photograph of the principal without seeing it.
Absolutely.
And sir, there's another question. Since the purchaser is signing, any change in the deed of transfer format?
Sorry?
Since the purchaser is signing the deed of transfer,
yeah.
There is any change in the format of the deed of transfer? Is
yes,
what
definitely. There is a format means actually you need not do any change in the body of the thing because he is not playing any role. When we say the in weakness whereof, then there you have to say the so and so place the signature there. Similarly, in the attestation too, you have to say the so and so purchase the seller as well as the purchaser both sides. But the body there is no change to take place because no role that the purchaser is playing apart from paying the consideration.
Thank you, sir. Felician, sir, the foreign banks are facing a huge issue with the changes to the powers of attorney ordinance since authority to local representatives are generally through general powers of attorney. It is impossible to identify the property in mortgage transactions, for instance, at the outset of powers of attorney issuance, and it is not practical to issue a power of attorney for each such transaction since time is of the essence. Is there any way this problem can be overcome? You want me to repeat the question, sir?
Yes, please. Yes, please.
The foreign banks are facing an issue with the changes in powers of attorney ordinance since authority to local representatives are generally through general powers of attorney. It is impossible to identify the property in mortgage transactions for instances at the outset of powers of attorney issuance, and it is not practical to issue a power of attorney for each such transaction since time is of the essence. Is there any way this problem can be solved?
I think the description of the property in the power of attorney is a must. We can't deviate from that this thing, isn't it, Mr. Arun?
Yeah, but the question is for what purpose? I don't think banks are asking the power of attorney for the purpose of the sale of properties. If they are asking for a general act, but I don't think you can do any transaction based on a general power of attorney. It has to be special. So that is where we have said because a lot of fraudulent transactions are taking place. That is the very reason we have put a special. But as far as the banks are concerned, if they are dead, because they can't have a general power of attorney and use for the purpose of the sale, because the law requires they identify the purpose or the land. So we are the meets and bounds. If it's a condominium, that has to be done. It may be it may be cumbersome, but for the purpose of prevention of frauds, we have to follow this. And that is the very reason even although this financial institution may like, that's the very reason we decided not to have the irrevocable powers amendment, which has been misused.
Arul Pragasam sir, but this is already about the photographs again, so I will pose this question to you. Sir, do we need to take photographs of both buyer and the seller?
It's not mandatory, it is advisable, but as far as the law is concerned, law says it's only the seller, not the buyer. It's advisable to do it safely.
Madam, do we have to certify the stamp duty receipt as well?
Yes, we have to. Once we get the original receipt will go with the duplicate. So the other two receipts, we can certify. We have to certify and paste it on our protocol and our original.
Thank you, madam. Sir, Arul Pragasam sir, when obtaining the last extract has been made compulsory, there will be a significant number of searches that increases in the land registries. Have any steps been taken on the side of the land registry to handle this increase of volumes?
You see, it is not this. I don't want to say anything. This question shows very well that who are the people who pose the question. That means they are obviously doing this search all this time. They are executing these without doing searches. So doing a search is a mandatory, even on the previous date in terms of section 31, subparagraph 17A. But the fact is, there was a 17B dispense which has been given. That was the person there. So this is nothing new. It was there in the 1907 legislation. After 15 years, all what they have done is we have removed the dispense part there. So it is a must. You have to search, plus you can get the certified copy. If you can search it there, getting a certified copy is not that difficult.
Thank you, sir. Felician sir, apart from the registration, do existing powers of attorneys already executed need to follow the new formalities? If they do not follow them, is it considered as invalid?
Yes, they have to be registered within 6 months they can register if they have not registered. Other than that, they should follow the existing provisions, otherwise it's not valid.
Thank you, sir. Madam, in the event a party is in overseas, can a scanned photograph passport size be affixed?
Parties abroad.
Yes, madam. In the event a party is in overseas, I think then there is a power of attorney has to be executed. The question is not that clear.
That clear. When a party is now in the actually, what the provision says is the executant's photograph has to be pasted. It does not talk about it. The executant is outside the country. It will be executant's power of attorney who will be signing the document. As Mr. Rupakasam correctly pointed out, because we are looking at the authenticity and the identification of the person who is signing. The question does not arise, but if you want to be more protection, you can get a scanned copy of the photograph and also fix that the section does not say not to do so. So we can have both photographs. As Mr. Adu Prakash earlier correctly said, I also fully agree that we should also two photographs and paste one on the original, one in our protocol. So that will be evidence for us. The scanned copy will do because that person does not fall into the category of executed in the meanings of this act.
Nirodha, one more clarification for to the earlier answer. In the Notaries Amendment Act, page 11, it says when to get photographs of parties. Because this is a very, very burning question of all the notaries, all asking the same question over and over again. In the case of a deed of transfer or a deed of gift, deed of exchange or a will, he shall affix to the original of such deed or instrument passport size certified photographs of parties. Parties means seller and buyer, donor and donee. If there is a deed of exchange, all parties. In a will, that is stated. So you have to get the photograph of the donee, of the transferee, of the other party. That is what what is stated in the Amendment Act.
Thank you, sir. Arupragasam, sir, if it is a mortgage bond, should both the mortgagor and mortgagee sign?
Yeah, I think we have said this over and over again, Nirodha. Strictly speaking, it's really no. But due to the interpretation given to the executor now, that is in terms of this Section 21, as executed, it is now must. Because otherwise, because it says in relation to other deed or instrument, parties to such deed or instrument. When you say parties, it is mortgagor and the mortgagee, and therefore caught up. But if they have followed what we have given in verbatim, all these problems will not arise. As far as our committee is concerned, our suggestion is only in regard to the deed of transfer and the gifts to make this left thumb impression and the photograph to be mandated, not other. But anyway, now we have to follow the law. In view of the definition to the word executed, apart from deed of transfer and the gift, it says in relation to any other instrument parties to such deed. So, as the plural word parties used, mortgagor and the mortgagee both have to sign.
Thank you, sir. Felician, sir.
Yes, Aniruddha, even the single one clearly says, අනෙකුත් ඔප්පු හෝ සාධන පත්‍ර සම්බන්ධයෙන් වන විට එකී ඔප්පුවේ හෝ සාධන පත්‍රයේ පාර්ශවකාරයන්. So English and the single have the same meaning. Therefore, it's the executant has given a separate meaning in this Notaries Amendment Act. That is why both, I think it will be safer. And also, what I feel is, we will say, if one side is going to be a problem, because until this is time tested and a judgment is given, a party can come and say, you have not signed, it's not valid. So why should we take a risk? It's better to have extra signature rather than not having the signature. So I think I strongly advise people, until it's interpreted by the Supreme Court in a case, we will have to continue to have both signatures, because the term parties have been mentioned in single and in this both for the executed in these acts. Thank you.
And also, Shiranti, just to say that, just like he said, අනෙකොත් ඔප්පුව සාධන පත්‍ර සම්බන්ධයෙන් වන විට ඉති ඔප්පුවේ සාධන පත්‍රයේ පාර්ශ්වකරුවන් plural.
They have given it in plural. බහුවචනයෙන් දීලා.
Yeah.
Thank you, madam, and thank you, sir. Felician, sir, the next question is, do these amendments apply for lease agreements as well?
Yes, these amendments also covered in certain sections. Because all these have the thumb impression is necessary for in all deeds. Section 15A, every executant, attorney, or board of directors should place thumb impression in respect of an instrument covering an immovable property.
Thank you, sir.
It covers.
Thank you, sir. Arupragasam, sir, license renewal takes more than 6 to 7 months to be received. Has this issue been raised? Since now it needs to be specifically mentioned in the attestation.
No, the question is, if you look at the attestation, Nirodha, the fact is, all what you have to say in the attestation is, now number one, I also certified that I have renewed my license. The question is, you can make the application, but as long as it says I have also certified, I have renewed the license for the year, I have applied for the renewal for the license for the current year. So, because you are not committing yourself, you say you have already renewed, and also for the next new, say if it is 2022, I have already made the application. So there is no issue at all. How long they take is immaterial.
Sir, there's another question. I will post that question to Arupragasam, sir. Should the attorney also put his fingerprint in the power of attorney? If so, should the attorney put his or her fingerprint as well?
Yes, because I think that's why Felicia was saying over and over, the factual position is on the face of it, of course, you have to, due to the interpretation, it says in singular, partial karuwan, the other said, executor has said, all parties, and therefore both have to sign and put the fingerprint too.
Thank you, sir. Felician, sir, in a foreign power powers of attorney, the attorney holder is not in a position to sign the power of attorney. What is the position on that?
I didn't get it.
In a foreign power of attorney, the attorney holder is not in a position to sign the power of attorney. What is the position on that?
The foreign power of attorney doesn't come under the notaries ordinance. It doesn't come under the notaries ordinance. So they are executed under the laws of that country. So his attorney signature is not necessary. Foreign power, in a foreign power of attorney, the principal is in another country and the attorney is in another country.
Thank you, sir. Madam, so can we still execute an irrevocable power of attorney?
Execute a irrevocable power of attorney for the reason that clearly says there cannot be revocable. It's a statutory mandatory rule. So we cannot execute a irrevocable power of attorney. Power of attorney is given actually for a certain purpose. So for that purpose only we can use power of attorney. In that case, after 5 years, we will have to have some sort of agreement whereby say another new power of attorney will be executed. We cannot circumvent the laws.
Thank you, madam. Arupragasam, sir. So
Just
here
to add a little to that, but Charan said was perfectly correct, but there is a qualification, but the state can do. Only the state can do irrevocable powers of attorney. Only state institution. Yes.
yes, sir, because I think the same question is repeated. So hereafter, buyer will have this question is for you, Arul Prakasam, sir. Hereafter, a buyer will have to do a power of attorney for purchase and for condominium. It will be 2 powers of attorneys, one at the time of signing and thereafter at the purchase.
I didn't understand the question properly.
After, buyer will have to do a power of attorney for the purchase, and when it comes to the condominiums, it will be 2 powers of attorneys, one at the time of signing and after that to purchase. As a purchaser and as a seller, they will have to do 2 powers of attorneys. The question, sir.
No. The question is if the purchaser is not in Sri Lanka, abroad, they can give one power of attorney to budget sign any documents. Question of 2 powers of attorney has been notarized. You can in one power of attorney, you can say to sign the sale and purchase agreement, and also for the purpose of purchasing. So depending on the process,
both can be done in one power of attorney.
Yeah. Unless it has been already done previously, then of course you have to get a fresh power of attorney falling within the ambit of the new law.
Thank you, sir. Felician, sir, is the photograph to be affixed to deed when the vendor is a company and when there are several vendors, how photographs are affixed?
If there are several vendors, you can attach a separate page, and on that you can affix the photographs and certify. Or before the attestation, you can affix the photographs, or after the attestation. If it is a company, the signatories will have to give the photograph, and those photographs have to be certified and signed.
I think the same question is asking, does it mean both parties should sign the power of attorney even though it is a foreign power of attorney? That question is already answered.
Foreign power of attorney not necessary.
Madam, if an Indian national who is a resident in Sri Lanka wants to sell his land in India via power of attorney, and that power of attorney drafted and emailed has to be attested by a Sri Lankan notary public.
The power of attorney, if the power of attorney will be signed in India, we cannot attest the power of attorney. If the power of attorney is to be signed in Sri Lanka, no one attest the power of attorney.
Thank you, madam. Arul Pragasam, sir, since the Sinhala version of the power of attorney ordinance mentions Pradhana Karu and not Liya Katsan Karanna, can the ordinance definition of Liya Katsan Karanna be used here? So say both principal and the power of attorney holder has to sign.
Sorry, say it again.
The declaration of the power of attorney ordinance mentions Pradana Karu and
Yes.
not Sankarana.
No, I
Can
do agree. That's exactly no. That's what I said initially. The fact is that end of the day, even if you look at, I said it earlier in English. I said where the left or right thumb impression of the grantor. It doesn't say that. But the question here arising is due to the interpretation in the notary's ordinance, because we are executing deeds based as notaries based on the notary's ordinance. These are subsequent X comes there. So the fact is, the notary's ordinance when categorically states that the executor is interpreted in such a way. Yeah, so I think, Niroda, I think we are now. You can see the practical problems that we face on these issues. I think we have to anyway. After I think 115 years, we have come forward a lot. But I think these lacunas in the law has to be corrected.
Thank you, sir. Felician, sir, can a last will be executed with 7 witnesses still, or has this been removed? I think we have discussed that.
Fine.
It's removed. It's no longer valid. Only it should be notarially executed before 2 witnesses and with the thumb impression of the testator.
Thank you, sir. Madam, in case of a mortgage previously signed by mortgagor only, according to the new amendment, do we need to get signatures of the mortgagee as well?
Nirodhana previously signed means now if the mortgage bond has been signed prior to the required date, we need not get the signature. But if the mortgage bond is signed after that date, both mortgage and mortgage will have to sign. I think my advice to the banks and the finance companies is you get a blank, you get a resolution where they name certain officers or senior managers to sign the mortgage bonds and get them to sign it. That you can't be whole time taking the board of directors in the banks and all the board of directors meet once a month. So they are going to have a practical difficulty. So because of that, because it goes on to say that even duly authorized officer. So by way of a resolution, if they can get these mortgage bonds will have to be signed by these and put their names, we will have to do that because I know in banks, some banks, foreign banks, they have given the power of attorney for the proxy to be signed by them. We annex that proxy and file it in court.
You know that in that example, if the mortgage bond was signed after the date where the act came into operation, and if the bank officer's signature has not been obtained, the notary can go for a dual attestation. That is the best thing he can do.
Thank you, sir. Arupragasam, sir, when prevention of frauds ordinance say in triplicate for transfer deed, does it mean original, counterpart original, duplicate and protocol?
No, I think Felician explained that because you see what happens is with the prevention of frauds ordinance, the section 16, the original act, there was an error in that one. Instead of the word triplicate, it was there duplicate. That is the error which has been corrected. So it's only original and the true copy, except for the last one, which is the duplicate, original, and the protocol. It's an error which has been corrected.
Thank you, sir. Felician says, suppose power of attorney is already executed in 2015, which is already in force, has no validity further to act on the same.
No, it's valid only for 5 years. So the 5 years period has left, it's not valid.
Thank you, sir. Then wills to be executed in triplicate, I think that question is answered.
Okay, just to add a little further, Nirodha, wills are secret documents. So no duplicates are going to the land registry, and therefore it is always original and a copy. That is original and the protocol. There is no duplicate. Therefore, it's always in duplicate.
Thank you, sir. And what if power of attorney registered prior and already lapsed 5 years, as the resource panel said, it has to be re-executed?
Yeah.
As per the power of as per the power of attorney ordinance amendment, power of attorney is valid for 5 years from the date of the execution, unless the period of validity of such power of attorney is specified in such power of attorney. Can you
Yes, what it says is that whatever reasons, it cannot exceed 5 years. But the period is given 2 years, it will then be, it will be cancelled within 2 years. You can't circumvent that by what is provided by statute. You cannot take away by saying, by of consent, this power of attorney can be for 5 years, 10 years. So therefore, what that means is, if it is for 2 years or 3 years, it expires then. Otherwise, automatically all the powers of attorneys expire within 5 years. Other than, as Mr. Arul Prakasham correctly said, their state has no powers of attorney.
Arul Prakasham sir, whether the parties will have to sign each and every page and they have to place the fingerprint on each and every page.
Generally, Nirodha, it is every 4th page you have to sign. If it is a single sheet, then each page has to be signed. Put the left or right thumb impression and to certify.
Thank you, sir. When we do an instrument under the regulation, sir, I think I will pose this question to you, sir. When we do any instrument under the Registration of Title Act, in the particular instrument also, do we have to affix the photograph?
Not necessary. Not necessary, because we are talking about Notaries Ordinance, and we have, I mean, normal deed registration. The title registration doesn't come under that category. So you don't have to fix photographs in title registration.
Arul Prakasham sir.
Just to add a little, I think we have to tell whoever the post the question, they should know there is a specific law in regard to the title registration. That is the very reason this act is not operating.
Thank you, sir. I will pose this question to Madam. Can we attest a transfer deed stating that no consideration was passed before me, or there has to be some consideration is passed before the notary at the time of execution?
You know that the new amendment clearly says how it has very categorically, it has explained very well how the consideration should be mentioned. I think this amendment was brought in by the committee thinking of the Money Laundering Act also. Therefore, it says of the consideration, if some amount has passed, you will have to say that amount has been passed. And if it otherwise, if it is paid earlier without our presence, we will have to get supporting documents to show that, and we will have to mention it, because we have to be very clear on this consideration that this is a very big question. I think as a notary, we should take the precautions and set out categorically and clearly how the consideration passed.
Thank you, Madam. I think we have answered. Nirodha, just to add one paragraph, I think answer to just to expand Shilanti's answer. If you look at Rule 20, subparagraph E, it says whether any money was paid or not in his presence as consideration or part of the consideration of the deed or instrument. If paid, actual amount in local currency, such payment, if the payment is made by a check, pay order, bank draft, or a banker's check for detail, such instrument shall be set out in the attestation in proof of such payment. So, if you take precautions like this, the notaries will not get land for money laundering act. Otherwise, the notary is also responsible. So, if a large amount of some billions have been paid, and if we do say that has been passed prior to the execution, the notary will be liable.
Okay, thank you, sir. And the time is up, and I'm still getting questions, but we have to conclude the session. And thank you very much for resource persons, and thank you, Bar Association of Sri Lanka, for organizing. And Adisha, over to you.
Thank you very much, Mrs. Nirodha Kalansurya. So, on behalf of the Bar Association of Sri Lanka and Seminars Committee, I would like to thank Mrs. Shiranti Gunawardana and Mr. Gigi Aruprakasam sir, Mr. Felician Fernando Pulis sir, and our moderator for the day, you ma'am, Mrs. Nirodha Kalansurya, for this very informative and valuable session. I would also like to say this is the highest number of participation in a webinar, so we are so glad and so excited and thank all of you who joined us through Zoom and YouTube and for your questions that have made this webinar an interesting one. Thank you, everyone. So we'll meet you on a different topic very soon. So good night and stay safe.